Hey everybody, this one is a major victory in my opinion, and so I want to make a video about it, and so other people can take advantage of what I did. They never tell you what exactly you did that made them decide to reevaluate, but I can tell you what I did, and then you can do similar things, or at least you'll know what I did and what the end result was. This is the actual letter that I got. This is City of Bedford in Texas, and dated June 10th. I just got it today. And after further review by the prosecutor, the case below has been dismissed. You're no longer required to appear for a jury trial. So they'd set it up for a jury trial, and that's it. That's all you get. Now, what I did is I filed a notice of void judgment, which was the final thing, and they actually, because the court was closed, I wasn't able to go there and get a file stamp on it, so I served it on them by registered mail with a self-addressed return envelope, and they didn't send it back to me. So what I did is I made a bar grievance complaint, and I attached it and said that it was served by certified mail and all that stuff. But they haven't received the bar grievance yet. Okay, I only sent this bar grievance here thing out Friday, and if you notice on the dismissed document, that was done on the 10th, which means today's the 15th, Monday. I mean, they mailed that thing before they got any bar grievance. Anyway, so they got a little love letter coming to them. Anyways, so we're going to go through what I did, and the notice of void judgment, I think, is what was fatal, okay, what was the final thing that worked, okay, but I did file a bill of particulars, okay, and here's the bill of particulars, and pursuant to the 6th Amendment, and see, here's the file stamp, okay, and so then I'm asking them a bunch of questions, okay. What's the jurisdiction and venue of the alleged cause of action in this instant citation? Keep firmly in mind those mentioned in Article 3 of the Constitution of the United States. And then what provisions of the Constitution, federal or state, confers authority to proceed? And, of course, these are all questions they don't want to answer. Okay, but, I filed this, like this was filed on the 23rd of March, so a long time ago. In what way does the person of the accused attached to the statute sought to be enforced? And does the word person mean the same thing in the statutes allegedly violated and as it does in Section 1 of the 14th Amendment? In other words, a corporation? If so, where's the articles of incorporation for the petitioner, and has petitioner's designated agent for service of process been served? It's a corporation, right? Now, as the bill of particulars, okay, you become the petitioner. That's why it's called... Well, I put the case number down here, but if you look on the footer, it's in re, okay, so it's really a separate action, okay, and so, anyway, so let's keep moving here. If so, where's the articles of incorporation? Is there a right to effective assistance of counsel on this instant case? If so, what provision of the Constitution, state or federal, secures such a right? Is there a right to a trial by jury according to the course of common law or otherwise in the instant case? And if so, secured by what provision of the Constitution? From what pools are members of the grand or petite jury summoned? And do these juries function at common law? If not, pursuant to what law do they function? See, these are all questions that they don't want to get into. Given that the current jurisdiction of the Supreme Court would seem to say there are no limits in the Commerce Clause powers of Congress, notwithstanding the later decision in U.S. versus Lopez that the court has ruled that these Commerce Clause powers are closely associated with the Admiralty jurisdiction, that Admiralty was decried by the colonists as the jurisdiction foreign to our Constitution, unacknowledged by our laws, found in the Declaration of Independence, and that state judicial courts of common law general jurisdiction are constitutionally forbidden to exercise Admiralty. See, it's military dictatorship is better terminology, but they don't want to go there. What's the actual foundation legal basis for the trial court? Anyways, I am going to upload these to Google Docs, and I will post since these have been filed into the case, they're public record. So they'll be posted they'll be below the video, will be links to these PDF files, okay, just the PDFs, so you can look them over. Word files, there's videos there's a video on the bill of particulars, there's a video on the motion for discovery, there's a video on the verification of complaint, and there's a video on the notice of void judgment, and word files are underneath all of those videos, so you can get the word files from there. But this is the actual files that were filed into the court. Who's the alleged injured party, or what constitutes the corpus delicti of the alleged crime, and what does loss of life, liberty, or property? What loss of life, liberty, or property is purportedly alleged in the charges as having caused by the accused? Observing the current Texas Constitution does not define them. Who is State of Texas? Who are named in the plaintiffs whose interests are purportedly represented by the prosecutor? And then this is the Rundle versus Delaware. My opinion has long been that the mayor and alderman of a corporation, or the present directors of the bank, or the present directors of a railroad company, or other similar corporations, are the true parties that are sued and are sued as trustees and representatives of the constantly changing stockholders. A corporation, therefore, being not a natural person, but a mere creature of the mind, invisible and intangible, cannot be a citizen of a state or of the United States. 1852, so that's before the 14th Amendment. The 14th Amendment made it all possible, the edict under martial law. But anyways, cannot be a citizen of a state or the United States, and cannot fall within the terms or power of the above-mentioned article, and can therefore neither plead nor be impleaded in the courts of the United States. With no provision of the bastardized version of the Texas Constitution allegedly currently in effect providing for the process being in the name of the state of Texas, on what authority are you proceeding to act to represent the people? What constitutes the consent of the governed, as in the Declaration of Independence, of any member of the de jure body politic to be regulated other than the common law of England? Okay, these are all questions that they don't want to have to answer. What are each and every one of the elements of the crime which the prosecution has to prove, and what are the definitions of any words and phrases in any alleged statutory acts, most particularly if different from the meanings of such words in everyday usage? What is the definition of scienter, which particularly in any allegedly applicable statute in which willfulness is an element, concentrating here on the violation of the known legal duty? What is the nature of the instant action? Civil, criminal, quasi-criminal, other? What is the factual foundation and legal basis for the choice? What is the level of burden of proof necessary to get a conviction? Beyond a reasonable doubt, clear and convincing, preponderance of the evidence. What's the actual foundation and legal basis to support this choice? And then you give them several choices here. The nominal plaintiff is the state of Texas, and yet the Texas Constitution makes no mention of who the state of Texas are, and no mention of any authority to process or issue in the name of state of Texas. Accordingly, a factual foundation and legal basis is essential to establish both the plaintiff and the alleged injury, and this information is demanded. And then another one, the second one is the nominal plaintiff is the state of Texas, yet Article 3, Section 2 of the Constitution for the United States provides in a relevant part, here and in all cases in which the state shall be a party, the Supreme Court shall have original jurisdiction. How can a trial court possibly have original jurisdiction, and how can any original jurisdiction in the instant case at all here? And then the third option is the laws attempted to be enforced here, either overtly in a criminal setting or a quasi-civil case, are purportedly promulgated in the name of the state of Texas, who are not only not defined anywhere in the Texas Constitution, but such laws are, for all apparent intents and purposes, bills of attainder, which are flatly prohibited in at least Articles 1, Section 9 or 10, as the case may be, of the Constitution of the United States. How can any such purportedly applicable laws apply in the instant case? What form of payment is accepted to pay the fine, or more accurately, to discharge the obligation for any fine, in what jurisdiction does such medium circulate? Well, they don't want to answer that one, that's for sure. If an offer of discharge of the obligation for the fine is made, Will the person accepting such offer be prepared to sign a receipt, declaration, under penalty of perjury that binds the state or United States and stops it from bringing further suit against the accused for willfully not paying the fine? What is the QSIP number and how is it related to the case? That's a good question. See, these are all questions that you do not want to go into. What is the QSIP number assigned to this case number or citation number of this case, and what legal significance does this number have? Has this case been monetized, and if so, by what agencies, based on what lawful authority? Yeah, is there a bond? Are other documents such as marriage licenses, birth certificates, and applications for credit, applications for Social Security, and the like created by individuals also monetized? Are any of these associated with the jurisdiction of the court? And if money in the form of debt has thus been created, and created based on the signature of an individual, why is that individual not credited with the creation of such money? Or, if so credited, into what account is such money placed? Is there an existence in artificial corporate entity known as the district court for the county of commercial county, or the functional equivalent thereof? If so, has this entity been recognized by, among other commercial banking entities, Dun and Bradstreet, pursuant to some or another registration process? If so, is this entity a for-profit corporation? If so, where can documents recording the official existence of this entity be obtained and or subpoenaed? Please provide a certificate of participation pursuant to 17 CFR section 240.15C2-12. This list of questions shall not be construed to be all-inclusive, and any and all of the above other questions pertaining to this bill of particulars likewise demand to be answered as well, consistent with and pursuant to the obligations of the government relative to administration of criminal law. The answers to the above questions in clear and unambiguous terms will be expected on a timely manner prior to any attempt at arraignment, consistent with the obligations imposed by the Constitution. They obviously ignored this because they went ahead and set a trial. So that means the arraignment, or actually they went and railroaded me. That's why I did the notice of void judgment. Anyways, it would be well to keep in mind the words of the Supreme Court of the United States regarding the duties of the public prosecutor. The United States Attorney is the representative not of an ordinary party to a controversy, but of a sovereignty whose obligation to govern impartially is as compelling upon its obligation to govern all, and whose interest, therefore, in a criminal prosecution is not that it shall win a case, but that justice shall be done. As such, he is, in a particular and very definite sense, a servant of the law, the twofold aim of which is that guilt shall not escape, nor innocence suffer. He may prosecute with earnestness and vigor, indeed he should do so, but while he may strike hard blows, he is not at liberty to strike foul ones. It is as much his duty to refrain from improper methods calculated to produce a wrongful conviction as it is to use every legitimate means to bring about a just one. And that's U.S. Supreme Court, United States versus Berger. And then decency, security, and liberty alike demand that government officials shall be subjected to the same rules of conduct that are commands to the citizen. In government of laws, existence of the government shall be imperiled if it fails to observe the law scrupulously. Our government is the potent, omnipresent teacher. For good or ill, it teaches the whole people by its example. Crime is contagious. If the government becomes a lawbreaker, it breeds contempt for law. It invites every man to become a law unto himself. It invites anarchy. To describe that in the administration of the criminal law, the end justifies the means. To declare that the government may commit crimes in order to secure the conviction of a private criminal would bring terrible retribution. Against that pernicious doctrine, this court should resolutely set its face. And that's U.S. Supreme Court again, Olmstead versus United States. Attention is also drawn to the case U.S. versus Smith, in which the court opined about the importance of the Bill of Particulars, that historically and functionally the Bill of Particulars is closely related to the indictment. Bills of Particulars relative to indictments have a brief history, nevertheless that history closely ties the Bill of Particulars to the indictment. Originally, indictments set forth the accusation in great detail, and there was no need for supplementation. The modern trend, however, has been towards more skeletal accusations to conceal martial law jurisdiction, possibly. combined with procedures provided access to omitted details if the defense has a legitimate need for them. Federal Rules of Civil Procedure 7F provides the opportunity for such access. That rule authorizes the court to direct the filing of a bill of particulars. This is a marked contrast to the provisions of Rule 16, which authorizes the court to direct that the government furnish to the defendant certain items of discovery. In addition, the multiple jurisdictions existing pursuant to at least federal law, the matter of jurisdiction and venue is the prime issue if timely challenged, as stated in U.S. v. Tully. It is unfortunate that the murderer should go unwhipped of justice, but it would be yet more unfortunate if any court should assume to try one charged of a crime without jurisdiction over the offense. Please address all correspondence to me at my address exactly as it appears below, unless you intend to engage in mail fraud pursuant to 18 U.S.C. 1342. All rights are reserved to return unopened any and all correspondence with the zip code absent clear and compelling authority for its use as being improperly addressed to an artificial entity in a federal, regional, martial law and or commercial jurisdiction and venue, as opposed to the lawful de jure state citizen, aka member of the sovereign body politic of the nation and republic, aka beneficiary of the trust known as the United States, domiciled in a state judicial district in a state admitted into this union. And so then signed and dated. So that's the end of the bill of particulars. Now, so I filed that into the case. I also filed a motion for discovery, and this is the motion for discovery, actually disclosure. And there's the file stamp. It was filed on March 28th as well. And so if the record does not show upon its face necessary to give jurisdiction, they will be presumed not to have existed. It is impossible to prove jurisdiction exists absent a substantial nexus with the state, such as voluntary subscription to license. All jurisdictional facts supporting claim that supposed jurisdiction exists must appear on the record of the court. Now, I've actually improved upon this since then. So the one that's below the video about this is better. And if you contact me, I'll send you the best one, or I'm just trying to think. Maybe I'll update. I'll probably update the best, the file that's already there, and replace it with the best one. Anyways, so and this is submitted on the 20th of March, 2020, and it was filed 28th. Okay, so motion for disclosure, request for disclosure number 1, and in all lawful arrest warrants, signed by a judge with all legal requirements of the Texas Code of Criminal Procedure, Article 1502, from Colleyville, Fort Worth, and Grapevine described in the police report, that fails to include any capias because a capias is not a warrant and used as an excuse for incarcerating the respondent in error. And the capias is not a warrant. This is Texas Criminal Appeals. Request number 2, the specific law that says that anyone can be arrested and incarcerated because of a capias. Yeah, if you can produce that, then you can produce your capias. And number 3, the names and oaths of office and anti-bribery statement of all Bedford jail guards present during the respondent error's incarceration and their training records to show their certifications for that type of work. The names and oaths of office and anti-bribery statements of all officers, of Officer Baxley and all of his supervisors, up to the Chief of Police, and their training records to show their certifications as peace officers. Number 5, all call logs and body cam and other video and audio recordings of Officer Baxley during his interaction with the respondent in error or during his interactions with Darren Swain, who was a guest in the respondent in error's car. Number 6, all call logs and body cam and other video and audio recordings of Officer Aguirre during his interactions with the respondent of error or during his interactions with Darren Swain, who was a guest in the respondent in error's car. Number 7, all video and audio recordings of the respondent in error while in the Euless jail. Number 8, all felony indictments that the respondent in error named from other states required from a fugitive from justice as required by Chapter 51 of the Texas Code of Criminal Procedure. Number 9, all evidence that shows that Glenn Winningham House affirmed the man has agreed to be surety for the Roman cult Sesta K Trust. Number 10, all evidence that shows that the respondent is a person as defined by the Texas Penal Code, the Texas Code of Criminal Procedure, the Texas Government Code, and the Texas Transportation Code. And there's a little cite to add some grist for the, it is impossible to prove jurisdiction exists absent a substantial nexus with the state, such as a voluntary subscription to a license. All jurisdictional facts supporting claim that supposed jurisdiction exists must appear on the record of the court. Number 11, the signed information from the county. There's supposed to be an information. Number 12, all Nord's correspondence video recordings that demonstrate that attempts were made to locate a magistrate before Glenn Winningham House of Fern, the man, was incarcerated. Yeah, they can't just put you in jail. They only supposed to put you in jail after they couldn't find a magistrate. And so where's the evidence that they did that? Number 13, the specific law that says that the respondent in error does not have a common law right to travel on the public highway with his private property, which also may be known as consumer goods under the Texas Business and Commerce Code. Number 14, the specific law that says that Deer Park Cash Cow, under the assumed name state of Texas, has a right to initiate a private cause of action against the respondent in error under Texas Penal Code. Yeah, if you can do that, then that's fine. Any and all contracts by which the respondent in error is agreed to be subject to Deer Park Cash Cow operating under their assumed name state of Texas, as evidenced by the certificate of fact issued by the Texas Secretary of State, document number 837579720002, a true copy of which is attached here, all of which is incorporated herein by reference in its entirety. Any and all contracts by which respondent in error is agreed to give up the Republican form of government guaranteed under the Constitution of the United States, Article 4, Section 4, in order to be subject to international law, military dictatorship, and edicts under martial law, Texas Business and Commerce Code, Texas Government Code, Texas Transportation Code, Texas Penal Code, and Texas Code of Criminal Procedure. And here's some court citations. The words penal and penalty in their strict primary sense denote a punishment, whether corporal or pecuniary, imposed and enforced by the state for a crime or offense against its laws. The noun penalty is defined forfeited to be forfeited for non-compliance with agreement. So where's this agreement? I want to talk about this agreement. Request for disclosure number 17. Any and all evidence that the respondent in error was carrying passengers or property for hire under Title 18 United States Code. Shoot, I left out the citation for that. Damn. That's Title 18 United States Code Section 31. I left that out. I can't believe I did that, but I did. The term motor vehicle means every description of carriage or other contrivance propelled or drawn by mechanical power and used for commercial purposes on the highways and the transportation of passengers and property, or property and cargo. A term used for commercial purposes means the carriage of persons or property for any fare, fee, rate, charge, or other consideration directly or indirectly in connection with any business or other undertaking intended for profit. And that's Title 18 United States Code Section 31. Anyways, number 18, any and all evidence that the respondent in error is a government employee or created by the government. And McCullough versus Maryland, U.S. Supreme Court, 1819, all subjects over which the sovereign power of the state extends are objects of taxation, but those over which it does not extend are exempt from taxation. This proposition may be pronounced as self-evident. The sovereignty of the state extends to everything which exists by its authority or permission. Number 18, any and all evidence that the respondent in error is receiving a privilege. Carlisle versus United States, U.S. Supreme Court says the rights of sovereignty extend to all persons and things not privileged. Okay? That means everybody's sovereign. You know, these pigs go around and say, oh yeah, he's a sovereign citizen. Well, everybody's sovereign that's not privileged. That is Southern Poverty Law Center communist slander is what that is, and anybody that brings that up is a communist. Anyways, number 18, any and all evidence that the respondent in error is a U.S. citizen. And where's the proof? Prove the evidence. And this is the certificate of fact from the Texas Secretary of State saying State of Texas is an assumed name for Deer Park Cash Cow. And if you search for it based on this number right here down in the bottom corner, you go to the Texas Secretary of State's website and you search for that document number. You can pull that up right on the Texas Secretary of State's website. Anyway, so that is, I served that on them. I filed that on the, I filed it on the 23rd of March. So, and then I filed this verification of complaint on the 21st of February. So I filed this even before all of that. And it says, before me personally appeared Glenn Winningham, House of Fern, being first put under affirmation and identified in accordance with law, deposes and says, the legal entity's name, Fern Glen Winningham, is assessed to K Trust, defendant herein. I have read but failed to understand the foregoing complaints filed herein, and each fact alleged therein is true and correct, and my best friend has knowledge and belief. Okay, so don't dispute a word of it. You can't create a controversy. So it's all true, but I don't understand it at all. And that's it, basically. And so then you serve it on them. That was filed on the 21st, and this was attached to it. Okay, this is the arraignment, right, that we talked about. And there's 2 charges: deceptively similar plates, failed to display driver's license. And they've all dropped that. Okay, that was filed on the 21st of February too. Along with it was all part of the same thing. So that's just a two-pager. And so then I filed this notice of void judgment. Okay, and so here it is. Bedford Kangaroo Court, Tim Murphy, bought and paid for clerk masquerading as a judge, Tarrant County, Texas, notice of void judgment. The probable cause determination and order of commitment issued by Tim Murphy after he took jurisdiction after entering a plea without authority, and everything subsequent are completely and utterly void and a fraud and a nullity for the following reasons. Okay, so again, in order for them to get me incarcerated, he had to issue a probable cause determination and a commitment order. Okay, order of commitment. Okay, I've seen some of these that were issued by other so-called courts. And so I know that he had to do that. Anyway, so Tim Murphy claims to be a judge, which means he's an officer of the court, which also means he's required to know the law. Therefore, Tim Murphy is required to know all of the following. And so then paragraph 2, Texas is under military occupation since 1863 when the Union Army invaded Texas. And so we're going to kind of move through this fairly quick. This whole thing is like 55 pages, and so I don't think you want to go to sleep. If you want to read all of that stuff, you can, download the file and read it. Anyways, so Texas is under military occupation. Martial law is the immediate and direct effect and consequence of occupation or conquest. The presence of the hostile army proclaims its martial law. Article 1, General Orders 100, the Lieber Code. And then territories considered this as a law of war on land, Hague Convention 4, Article 42. The occupation continues to this day. Since there was no treaty of peace, there's been no special proclamations. Article 2 of General Orders 100. All police are military police. All police are privateers operating on the high seas of commerce, operating under international law because they're U.S. citizens of the District of Columbia. They're operating under international law under the Federal Tax Lien Act of 1966. Martial law only affects subjects of the enemy and aliens, and subjects are government employees and corporations and anything created by the government or have received privileges by way of a contract, and that's Carlisle versus United States. And it's impossible to prove jurisdiction exists absent a substantial nexus with the state. And so, and here's some court citations. Since the consideration is the lifeblood of any agreement or quasi-agreement, and then the absence, anyways, it talks about contracts here. Let a state be considered as subordinate to the people, everything else be subordinate to the state. The term resident and citizen of the United States is distinguished from a citizen of one of the several states in that the former is a special class of citizen created by Congress. And subjects are subject to the regulations and therefore property and slaves, and that's true. Congress shall have power, this is Article 4, Section 3, Clause 2 of the Constitution. Congress shall have power to dispose of and make all needful rules and regulations respecting other property belonging to the United States. If you turn yourself into a corporation, then you are property. You are a slave, and they can dispose of you. They can blow your brains out if they feel like it, because that's disposing of you. And this is true in all corporations masquerading as governments. This is the Canadian Ownership and Control Determination Act. Owned means subject to the regulations. Okay, so now go back to here. Congress shall have power to dispose of and make all needful rules and regulations respecting the other property. It's the same thing, okay? Rules and regulations. If you're subject to the regulations, you're property. Owned means subject to the regulations. Military jurisdictions, two kinds, statutes and martial law, the common law of war. Okay, so all statutes are edicts under martial law. And there's some court cases, you can look at them, with the so-called judge being a bought and paid for a clerk masquerading as a judge, And when the clerk masquerades as a judge as an agent for the administrative agency, it's also always a kangaroo court and a bill of pains and penalties. See, that bill of particulars kind of alludes to that, right? Which is a violation of the Constitution, and any bought and paid for a clerk enforcing administrative law pretending to be a judge does not have authority to do anything judicial like issue warrants or orders. Tim Murphy entered a plea while operating as a military commissioner under martial law because after threatening contempt, which is what military commissioners do under military dictatorship, which means Murphy's not competent to do anything judicial like enter a plea. When the respondent in error was being unlawfully held in Murphy's jail, Murphy asked the respondent in error if he understood the charges, and the respondent told Murphy, "I don't understand any of this." Therefore, Murphy has no jurisdiction, there is no plea, and Murphy's in bad behavior and fails to be a judge. And Article 3, Section 1 says the judges of both Supreme and inferior court shall hold their office during good behavior. Okay, they have to be in good behavior. The Bedford officer Baxley admits that he witnessed no crime in the police report, a true copy of which is attached here to, all of which is incorporated herein by reference in its entirety, that the reason for the stop is a Republic of Texas plate, and the charges are all Class C misdemeanors, which are punishable by fine only. And a crime is only something that can be punished by jail under Texas Government Code 79.001. Therefore, Baxley had no probable cause to stop the respondent in error, which means Baxley violated the respondent in error's Article 4 Amendment right to be free from unreasonable search and seizure, and it failed to be a lawful arrest, but instead a false arrest and a malicious prosecution. Although probable cause may not be inferred from malice, malice may be inferred from lack of probable cause. Okay, so if there's no probable cause, then that's by definition a malicious prosecution. Therefore, there was no crime and no probable cause to stop the respondent in error, and in the first place, which means there's no lawful arrest, no requirement to produce identification under their edict under martial law. Tim Murphy has full knowledge that the respondent in error has a common law right to travel with his private property on the public highway, and here's a bunch of court cases that talk about it. Murphy is in bad behavior and fails to be a judge. Again, that's Article 3, Section 1. Murphy intended to conspire with Baxley, Aguirre, Butler, the prosecutor, and others to convert the respondent in error's common law right to travel into the on the public highway into a privilege. And the claim and exercise of a constitutionally guaranteed right cannot be converted into a crime. No state shall convert a liberty into a privilege, license it, charge a fee, therefore. There can be no sanction or penalty imposed upon one because of his exercise of constitutional rights. If the state converts a right or liberty into privilege, the citizen can ignore the license and fee and engage in the right with impunity. And Murphy's in bad behavior and fails to be a judge. Tim Murphy's full knowledge that under the international law, Texas Business and Commerce Code, that's modeled after a private international law called the Uniform Commercial Code, that are also edicts under martial law, the respondent in error has a right to own consumer goods instead of business equipment. And so then there's a bunch of court citations under that. And under their edicts under martial law called the Texas Constitution, consumer goods, like the respondent in error's private conveyance, are not subject to taxation. And Texas edicts under martial law require that no political subdivision will require anyone to register the vehicle, pay a tax, or pay a tax for a driver's license. And the Supreme Court of the United States has ruled that income is corporate profits. Therefore, your entire edicts under martial law called Texas Transportation Code is for commercial vehicles carrying passengers or property for hire by U.S. citizens pursuant to your edict under martial law, Title 18, United States Code, Section 31. Therefore, there was no crime and probable cause to stop the respondent in error in the first place, which means there's no lawful arrest, no requirement to produce identification under that edict under martial law. But Tim Murphy intends to perjure his oath of office by denying the respondent of error a Republican form of government as required by Article 4, Section 4 of the Constitution, and Tim Murphy intends to facilitate the malicious prosecution by working for the prosecution in violation of his own edict under martial law, Texas Constitution, Article 2, Section 1, that says that the powers of government of the state of Texas shall be divided into 3 distinct departments, each of which shall be confided in separate body of magistracy, to wit, those which are legislative to one, those which are executive to another, and those which are judicial to another. And no person or collection of persons being in one of these departments shall exercise any power properly attached to either of the others. and thereby demonstrated that Murphy intends to perjure his oath because his oath of office is to me. And because it brings into action and enforces this great and glorious principle that the people are the sovereign of this country, and consequently that fellow citizens and joint sovereigns cannot be degraded by appearing with each other in their own courts to have their controversies determined. That's U.S. Supreme Court, Chisholm versus Georgia, 1794 or something like that. Because my ancestors were in Virginia prior to the War of Independence, the right of blood and kindred cannot be destroyed by any civil law. That's a maxim of law. And the power which is derived cannot be greater than that from which it is derived. So his authority comes from me, as evidenced by the statement of original status that is in the corporate denial affidavit that is recorded with the Pinal County Recorder at fee number 2013-032373 on the 19th of April, 2013. 10 years ago, almost 8 years, a true copy of which is attached here to all of which is incorporated herein by reference in its entirety, and Murphy's operating under the authority of the respondent in error. Sovereignty itself, of course, is not subject to law, for it is the author and source of law, but in our system, while sovereign powers are delegated to the agencies of government, sovereignty itself remains with the people, by whom and for whom all government exists and acts. Which means he operates under my authority. A sovereign is exempt from suit, not because of any formal conception or obsolete theory, but on the logical and practical ground that there can be no legal right as against the authority that makes the law on which the right depends. I mean, Murphy's got a problem here, folks. And Murphy's in bad behavior and fails to be a judge. That's Article 3, Section 1. The respondent in error is a man, and it is impossible for the respondent in error to be a U.S. citizen because the respondent in error is white. And 42 U.S.C. 1982, all citizens of the United States shall have the same right in every state and territory as enjoyed by white citizens thereof to inherit, purchase, lease, sell, hold real and personal property. And that's current law, folks. And the 14th Amendment requires that only persons born or naturalized in the United States, this is Article 4 in Section 14, Section 1, 14th Amendment, Section 1, and the hearsay evidence shows that respondent in error was given birth in the soil of Alberta, Canada. But having said that, the respondent in error does the hearsay evidence shows that was given soil in Alberta, Canada. Having said that, it's hearsay, right? The respondent in error does remember walking to school in Peace River, Alberta, about 600 miles north of the Montana border in the winter when it was minus 69 degrees Fahrenheit. And the respondent in error does remember finishing high school in 1975 in Raymond, Alberta, about 20 miles north of the Montana border. And neither has the respondent in error been naturalized because the sole authority is through Attorney General by taking the oath of allegiance, which the respondent in error has failed to do. And this is 8 U.S.C. 1421. The sole authority to naturalize as citizens of the United States is conferred upon the Attorney General, and he talks about the procedure. Neither is the respondent in error a resident alien because the respondent in error has failed to make application for a green card, but the respondent in error did claim American nationality through the United States Secretary of State by right of blood because the respondent in error has ancestors who were here prior to the War of Independence. And then there's the maxim of law, the right of blood and kindred cannot be destroyed by any civil law, and the power which is derived cannot be greater than that from which it is derived. All of which is evidenced in the statement of original status in the corporate denial affidavit that's recorded with the Pinal County Recorder at fee number 2013-032373, and the U.S. passport issued to the respondent in error under authority of the United States Secretary of State instead of the National Passport Center. True copies of each of which are attached here to, all of each of which are incorporated herein by reference in entirety, which are the unrebutted truth and public policy, which means that the respondent in error is a free inhabitant as found in Articles of Confederation, Article 4. And in 1871, Congress created the unconstitutional municipal corporation called United States of America to operate as a government of the District of Columbia as an edict under martial law. And this is Downs versus Bidwell. Two national governments exist, one to be maintained under the Constitution with all its restrictions, the other to be maintained by Congress outside and independently of that instrument. And the unconstitutional municipal corporation fails to be the United States of America, as found in Articles of Confederation, Article 1. The style of this confederacy shall be the United States of America. And in 1845, the state of Texas is alleged to have joined the Confederacy and the Union, And this is 9 Stat 1, be it enacted by the Senate and House of Representatives of the United States of America and Congress assembled, that all laws of the United States are hereby declared to extend to and over and to have full force and effect within the state of Texas, admitted at the present session of Congress into the Confederacy and Union of the United States. Which fails to be the state of Texas, there shall be a seal. This is Article Texas Constitution, Section 19. There shall be a seal of the state, which shall be kept by the Secretary of State and used by him officially under the direction of the governor. The seal of the state shall have a star of 5 points circling the olive and live oak branches, and the words, the state of Texas. And the state of Texas is a profit corporation that was set up in 1845, as evidenced by the affidavit of Daniel Lee Swank, together with the 2-page Dun & Bradstreet report that are attached here too, all of which is recorded with the Liberty County Clerk on June 6, 2008, as filing number 2008-010522, for a total of 3 pages, a true copy of which is attached to the corporate denial affidavit, recorded in Pinal County Recorder at fee number 2013-032373, all of which is incorporated herein by reference in its entirety, and nobody has any allegiance to an unconstitutional Roman cult municipal corporation, and only those born in federal territory qualify as U.S. citizens. And this is U.S. Supreme Court 1884. Merely being native born within the territorial limits of the United States of America does not make such an inhabitant a citizen of the United States, subject to the jurisdiction of the 14th Amendment. And it goes on, the persons declared to be citizens are all persons born or naturalized in the United States and subject to the jurisdiction thereof. The evident meaning of these last words is not merely subject in some respect or degree to the jurisdiction of the United States, but completely subject. And Murphy's in bad behavior and fails to be a judge, Article 3, Section 1. The respondent in error is entitled to a Republican form of government, Article 4, Section 4, which fails to include military commissioners operating under General Orders 100. And this is military jurisdictions, 2 kinds, talking about statutes. And then here, this is FM 27-5, United States Army Navy Manual on Civil Affairs, 1947. Civil affairs and military government personnel are charged with the following: establishment and administration of military commissioners, provost courts, and special military government courts, and their jurisdiction and procedure; supervision, control, or closing, if necessary, of local criminal and civil courts; supervision of members of the local bar; decisions as to modifications of or suspension of local criminal and civil laws; general legal advice and assistance in all aspects of the occupation. And a Republican form of government fails to include any star chambers. The corrupt Star Chamber Courts of England requires defendants to have counsel. Star Chamber stood for swiftness and arbitrary power. It's a limitation on the common law. And a Republican form of government fails to include any statutes, codes, rules, or regulations, because all statutes, codes, rules, and regulations are taken in martial law, as described herein, which only to subjects of the enemy and aliens, and U.S. versus United Mine Workers, but in fact and in law, such statutes are intended to be applicable to those who are here as residents in this state under the Interstate Commerce Clause of the Federal Constitution and the so-called 14th Amendment, U.S. Supreme Court, 1947. But Murphy intends to perjure his oath of office by subjecting the respondent in error to his military dictatorship. And this is Causes and Necessities for Taking Up Arms, 1775. Statutes have passed extending the courts of admiralty and vice-admiralty far beyond their ancient limits for depriving us of the accustomed and inestimable privilege of trial by jury in cases affecting both life and property, to supersede the course of common law, instead thereof to publish and order the use and exercise of the law martial. And for altering fundamentally the form of government established by charter, we saw the misery to which such despotism would reduce us, okay? Despotism is military dictatorship. And this is U.S. Supreme Court, Chisholm versus Georgia. In despotic governments, the government has usurped in similar manner both upon the state and the people. Hence, all arbitrary doctrines and pretensions concerning the supreme, absolute, and uncontrollable power of government in each man is degraded from the prime rank which he ought to hold in human affairs. In the latter, the state as well as the man is degraded. Of both degradations, striking instances occur in history, in politics, and in common life. Under international law, Dred Scott versus Sanford, But in considering the question before us, it must be borne in mind that there is no law of nations standing between the people of the United States and their government, and interfering with their relation to each other. The powers of the government and the rights of citizens under it are positive, practical regulations plainly written down. The people of the United States have delegated it certain enumerated powers and forbidden it to exercise others. Okay, U.S. Supreme Court, 1857. Now, the important thing here is there's no law of nations standing between the people of the United States and their government, okay? So there's no international law. The purpose of the government is to shield us from international law, is what it's supposed to do. And Chisholm versus Georgia, because it brings into action and enforces this great and glorious principle that the people are the sovereign of this country, and consequently that fellow citizens and joint sovereigns cannot be degraded by appearing with each other in their own courts to have their controversies determined. And Murphy's in bad behavior and fails to be a judge. The judges of both supreme and inferior courts, again, Article 3, Section 1. Murphy has demonstrated that he intends to assault the respondent in error with his quasi-contract, okay? And so then there's some court citations on quasi-contracts. And it's absolutely critical evidence of the Roman cult Sestake Trust. It's absolutely critical to fabricate evidence of the Roman cult Sestake Trust slave. And this is quasi-constructive. Quasi-contracts are based solely upon the legal fiction or fiction of law. And Murphy knows that their Roman cult Sestake Trust is a fictitious entity, and a fiction can only appear on paper, but he intended to drag a man into his so-called court as evidenced by his perjury of oath when he illegally and unlawfully issued his order of probable cause and order of commitment. And this is Braswell versus United States, but individuals, when acting as representatives of a collective group, cannot be said to be exercising their personal rights and duties, nor be entitled to their purely personal privileges. Rather, they assume the rights, duties, and privileges of the artificial entity or association of which they are agents or officers, and they are bound by its obligations. Braswell versus United States, 1988. By using their private international law, defined by the Unidroit statute under the Texas Business and Commerce Code, whenever the Uniform Commercial Code creates a presumption with respect to a fact or provides that a fact is presumed, the trier of fact must find the existence of the fact unless and until evidence is introduced that supports a finding of its non-existence. That's Texas Business and Commerce Code, section 1.206, and forge the respondent in error's signature onto their so-called contract and settlement to slavery as surety for the Roman cult Sestake Trust. And this is Texas Business and Commerce Code 3.308. In an action with respect to an instrument, the authenticity of and authority to make each signature on the instrument are admitted unless specifically denied in the pleading. So they forge your signature onto a contract. He, the prisoner, has, as a consequence of his crime, not only forfeited his liberty, but all his personal rights as those which the law and its humanity affords him. He is, for the time being, a slave of the state. It's all about slavery. They sell you into slavery. These people are Satanists. They're diabolically evil. And we need to put a stop. We need to get rid of this evil from our land. The following rules apply in an action on a certificated security against the issuer, unless specifically denied in the pleadings. Each signature on a security certificate or in a necessary endorsement is admitted. That's Texas Business and Commerce Code 8.114. And Murphy knows that their Roman cult Sestake Trust is a fictitious entity and a fiction can only appear on paper, but he intended to drag a man into his so-called court for their unconstitutional debtor's prison and his extortion racket. And Texas Constitution, Article 1, Section 18, imprisonment, no person shall ever be imprisoned for debt. All of which is a violation of their own edicts under martial law, tampering with or fabricating physical evidence, Texas Penal Code 37.09, which is evidence that there's a seditious conspiracy under the Texas Penal Code, a penal action. And so then, well, I read that article or that section, here it is right here. The words penal and penalty in the strict primary sense denote a punishment. Well, let's go back here. Under the Texas Penal Code, and a penal code is a civil suit. Okay, a penal code is a civil suit brought for recovery of a statutory forfeiture, and a penal code is has to do with a breach of contract. Okay, and I already read this one. We'll read it again. The words penal and penalty in their strict primary sense denote a punishment, whether corporal or pecuniary, imposed and enforced by the state for a crime or offense against its laws. The noun penalty is defined forfeited to be forfeited for non-compliance with an agreement. And a penal action falls under the Roman cult's ecclesiastical law. Pecuniary clause. See, notice it goes. You go back up here, you find pecuniary. Where is that pecuniary? Whether corporal or pecuniary. Pecuniary cause, such as arising of the withholding of ecclesiastical dues, or the doing or neglecting some act relating to the church, whereby some damage accrues to the plaintiff towards obtaining satisfaction, for which he is permitted to institute a suit in the spiritual court. Such, for instance, are the subtraction or withholding of tithes to the parson or vicar. So they steal your money, and if you don't pay it, they put you in jail. The non-payment of ecclesiastical dues to the clergy. This is as old as time itself. It's been going on from the beginning of time. It's all tied to the Roman cult, thereby subjecting the respondent heir to their satanic religious ceremony in violation of 18 U.S.C. 247, and Murphy's in bad behavior and fails to be a judge. Article 3, Section 1. Because the respondent heir failed to provide identification, the Bedford hired thugs forcibly engaged in the theft of the respondent heir's private property, image, fingerprints, etc., and used the FBI database to identify the respondent heir. All information on all government databases is government property. Therefore, any name in a government database is a Sesticate trust. And this is the DC Code. And in Section 2, where it says that the interpretation and construction of said code, the following rules shall be observed, namely, the word person shall be held to apply to partnerships and corporation, a legal estate to be the Sesticate use, that's at 31 Stat 1432, and they even presume you're dead. And this is at Section 252, 31 Stat 1230, presumption of death. Every taxpayer is a Sesticate trust having sufficient interest in preventing the abuse of the trust to be recognized in the field of this court's prerogative jurisdiction. Henry Bolins, that's a summary from that case. A citizen of the United States is a civilly dead entity operating as co-trustee and co-beneficiary. The constructive Sesticate Trust of U.S. Inc. under the 14th Amendment, which upholds the debt of USA and U.S. Inc. And that's congressional record, and that's a summary, okay? People have contacted me and say, I can't find that. Well, it's not there. It's a summary of 5 pages of the congressional record. You ever looked at the congressional record? It's very tiny print. There's 3 columns. And so it's a summary of 5 pages. And yet the Sesticate Trust was created by the Roman cult. And this is Tomlin's Law Dictionary, 1835 edition, volume 2. Yet still it was found difficult to set bounds to ecclesiastical ingenuity. For when they were driven all of their former holes, they devised a new method of conveyance by which the lands were granted, not to themselves directly, but to nominal fiefs, to the use of the religious houses, thus distinguishing between the possession and the use, and the receiving the actual profits, while the season of the land remained in the nominal fief, who was held by the courts of equity, then under the direction of the clergy, that's the Roman cult, folks, to be bound in conscience to account to the, that's taxes, folks, to his Sesticate use for the rents and emoluments of the estate. And it is to these inventions that our practitioners are indebted for the introduction of uses and trusts, the foundation of modern conveyancing. Which is why they spell the name Fern Glen Winningham in all block capital letters. A U.S. citizen is a Roman cult Sesticate trust, and here's some court cases which falls under the definition of corporation at Title 15 United States Code, Section 44, which is why a U.S. citizen has no rights because corporations have no rights, but are property, which is why a U.S. citizen is a slave, because a slave is property. Privileges and immunities of citizens of the United States do not necessarily include all the rights protected by the first 8 amendments of the federal Constitution against the powers of the federal government. The right to trial by jury in civil cases guaranteed by the 7th Amendment. The right to bear arms guaranteed by the 2nd Amendment. They have been distinctly held not to be privileges and immunities of citizens of the United States, guaranteed by the 14th Amendment against abridgment by the states. And in effect, the same decision was made in respect to the guarantee against prosecution, except by indictment of a grand jury contained in the 5th Amendment, and in respect to the right to be confronted with witnesses contained in the 6th Amendment. That's West versus Louisiana, U.S. Supreme Court. The only absolute and unqualified right of a United States citizen is to residence with the territorial boundaries of the United States. U.S. citizens fail to be entitled to Article 3 court or a Republican form of government, but instead get a military dictatorship under Congress's plenary power. And this is National Mutual Insurance Company, the District of Columbia versus Tidewater Transfer Company, U.S. Supreme Court, 1948, We therefore decline to overrule the opinion of Chief Justice Marshall. We hold that the District of Columbia is not a state within Article 3 of the Constitution. In other words, cases between citizens of the district and those of the states are not included in the catalog of controversies over which Congress could give jurisdiction to the federal courts by virtue of Article 3. In other words, Congress has exclusive legislative jurisdiction over citizens of Washington District of Columbia, and through their plenary power, nationally, plenary power, that's military dictatorship, folks, nationally covers those citizens even when in one of the several states, as though the district expands for the purpose of regulating its citizens wherever they go throughout the states of the Union. And U.S. citizens fall under international law under the Hague Convention on the law applicable to trusts and their recognition, which is concluded on 1st of July 1985 and entered into force on 1st of January 1992, as well as the Hague Convention concerning international administration of states, which was concluded on 2nd of October 1973, both of which are part of the Hague Conference on Private International Law, which is part of the Uniform Commercial Codes in there, where it talks about birth certificates on Article 22 and 23, and I'll let you read those. And Murphy's in bad behavior and fails to be a judge, Article 3, Section 1. A name is hearsay, an address is hearsay, a date of birth is hearsay, all of which is obtained from the respondent in error from a hearsay database by illegal search and seizure in violation of Article 4, an amendment to the Constitution of the United States of America, and with full support and assistance of Tim Murphy, as evidenced by the police report, a true copy of which is attached here to, all of which is incorporated herein by reference in its entirety. Furthermore, Baxley and his Bedford police Gestapo buddies, with full support and assistance of Murphy, denied the respondent in error his right to remain silent, which is guaranteed under the Article 5 an amendment to the Constitution for the United States of America, as evidence in the police report, a true copy of which is attached here to, all of which is incorporated herein by reference in its entirety. Hearsay evidence is inadmissible under Rule 802 of the Edicts under Martial Law Rules of Evidence. The plaintiff's state of Texas in his so-called arraignment, a true copy of which is attached here to, all of which is incorporated herein by reference in its entirety, is an assumed name for Deer Park Cash Cow, as evidenced by the certificate of fact downloaded from the Texas Secretary of State's website under the document number 837579720002. On the lower right corner of the certificate of fact, if you go to the Texas Secretary of State's website and search for the document at the following link, you can pull up the document right from the Texas Secretary of State website. So they can drag me into their kangaroo court, which also shows State of Texas is actually Deer Park Cash Cow LLC, and your Deer Park Cash Cow, using their assumed name State of Texas, has no private cause of action for alleged violations of the Penal Code, to the extent that Deer Park Cash Cow LLC seeks to hold anyone liable for alleged violations of the Texas Penal Code, such a claim is without a basis in law or fact. And this is a Texas Court of Appeals citation. Texas does not recognize private cause of action for penal code violations. Therefore, which is true because it's a breach of contract, so they can't recognize private cause of actions for penal code violations. Think about it. Remember, it's breach of contract. Therefore, Deer Park Cash Cow LLC's claims of any alleged violation of Texas Penal Code are legally meritless and fail as a matter of law. A claim has no arguable basis in law if it's based on an indisputably meritless legal theory. But Murphy, your bought and paid for bar member whores, selling their justice, insist on assaulting me with their edicts and their military dictatorship despotism, insist on assaulting me with their Deer Park Cash Cow, using the assumed name State of Texas in their Class C misdemeanor offenses that fail to be crimes, as evidenced in, and here's a list of them all of which so-called complaints are made under oath by some coward, in which he told Baxley, which he says that Baxley told him that these alleged offenses therefore have no verified complaint by anyone with first-hand knowledge of anything. And their coward refuses to identify themselves and is perjuring their oath of office, a true copy of which is attached here to, all of which is incorporated herein by reference in their entirety, because their oath of office is to me, and because it brings into action, and because my ancestors were in Virginia prior to the War of Independence, as evidenced in the Statement of Original Status that's in the Corporate Denial Affidavit, and it goes through all of that. And Murphy, the bought and paid for whore, has used his offenses that failed to be crimes as justification to issue a capias that fails to be warrants. and he is prohibited from issuing capias till after he obtains jurisdiction and holds a show trial in his kangaroo court. And that's what their edicts under martial law say. And Murphy sends his hired thugs out with guns to arrest me with no authority whatsoever, and Murphy's in bad behavior and fails to be a judge. Article 3, Section 1. The bottom line is there's no evidence. What page are we on? Oh, we're getting halfway through. We're halfway through. And then there's the attachments. The bottom line is there is no evidence that the respondent in error is subject to Texas codes. The name is inadmissible. The address is inadmissible. The date of birth is inadmissible. And all the hearsay information taken from the hearsay database is inadmissible. And any court is required to presume it fails to exist. If the record does not show upon its face the facts necessary to give jurisdiction, they will be presumed not to exist. And since the respondent in error is a direct descendant of we the people, it is evidence that they're involved in a seditious conspiracy to use their martial law to overthrow the respondent in error. A state like a merchant makes a contract, a dishonest state like a dishonest merchant willfully refuses to discharge it. In doing this, I shall have occasion incidentally to evince how true it is that states and governments were made for man, and at the same time how true it is that his creatures and servants have first deceived, next vilified, and at last oppressed their master and maker. Those are two citations from Chisholm versus Georgia, U.S. Supreme Court. And this last citation, I've read it before, Chisholm versus Georgia, U.S. Supreme Court. And Murphy's in bad behavior and fails to be a judge. There are 7 elements of jurisdiction, and so then I go through those, and I'm not going to, if you want to read them, you're welcome to. I'm going to kind of breeze through this stuff because it's again, you just throw everything you can at them. And if you want to read it, knock yourself out. Murphy intends to engage in abuse of official capacity. I go through here. Where do I start? Right. Murphy's required to know the Class C misdemeanor is a civil matter. Murphy's required to know that no judge has permission to issue a warrant for failure to appear for a civil matter. Murphy's required to know that a penalty for failure to appear for a civil matter is a fine only. Murphy's required to know that any judge may not issue a capias until he has jurisdiction, has held a trial, and obtained a conviction. Murphy's required to know that when he is representing Deer Park Cash Cow, he fails to be in his official capacity as a judge, but is instead in his private capacity as a bought and paid for clerk masquerading as a judge, and in that capacity he's incapable of doing anything judicial, like issue any order or any warrant or any capias. And this is Clearfield Trust Company. Governments descend to the level of mere private corporations and take on the characteristics of a mere private citizen, where private corporate commercial paper, Federal Reserve notes, and securities checks are as concerned. For purposes of suits, such corporations and individuals are regarded as entities entirely separate from government. Murphy intends to engage in official oppression. Okay, and so then these are all talking about... here's official oppression. This is Texas Penal Code. Murphy intends to engage in abuse of official capacity, and this Texas Penal Code. Murphy intends to subject the respondent in error to deprive of his common law right to travel with his private property on the public highway as part of his genocide agenda against Texas nationals. And this is the definition of genocide. Subjects the grouper to conditions of life that intend to cause the physical destruction of the group in whole or in part. Murphy intended to conspire with Baxley, Aguirre, Butler, the prosecutor, and others to threaten, intimidate, injure, and oppress the respondent in the free exercise of his common law right. Okay, I'm using the words under Title 18, United States Code, Section 241. Murphy intended to subject the respondent in error to the deprivation of his right under the international law, edicts, the Texas Business and Commerce Code to own consumer goods instead of business equipment. Murphy intended to conspire with Baxley and others to threaten, intimidate, injure, and oppress in the free exercise of his right under to consumer goods instead of business equipment. Murphy intended to subject the respondent in error to deprivation of his right to a Republican form of government. Intended to conspire to threaten, intimidate, injure, and oppress the respondent in error in the free exercise of his right to a Republican form of government. I'm just listing all the felonies. Intended to conspire with Baxley to threaten, injure, and oppress the respondent in error in free exercise of his right to be free from unreasonable search and seizure. Intended to subject the respondent in error to the deprivation of the right to be free from unreasonable search and seizure. So one of them is threatening. That's a conspiracy one, 241. And the other one is subjecting me, and that's under 242. Murphy's required to know the respondent in error constitutional right to remain silent, and his constitutional right to fail to give evidence and himself cannot be converted into a crime. Murphy intended to subject to the respondent in error to his deprivation of his right to fail to give evidence against himself. Anyways, so I'm just listing all of these crimes that they're involved in. Demonstrate he intends to perjure his oath of office, requirements to support. And so that's 242, respondent, Republican form of government. It's demonstrated that he intends to be a bought and paid for clerk masquerading as a judge. It's a kangaroo court and a bill of pains and penalties. We've already talked about that, and it's a void judgment. Everything Murphy does is brutum fulmen. Murphy's in bad behavior and fails to be a judge. Murphy's demonstrated he's in bad behavior. Murphy intends to be a military commissioner under martial law under Article 3 of General Orders 100. Murphy's in bad behavior and fails to be a judge. Murphy's falsely accused of the respondent in error of being a defendant, thereby demonstrating that this case is prejudged because the defendant under their edicts under martial law is someone accused of a crime. And that's not a crime. A Class C misdemeanor is not a crime. When all the charges in the case are Class C misdemeanors, which are punishable by fine only, and are under edicts, a crime is defined an offense that's punishable by jail. Therefore, a Class C misdemeanor fails to be a crime, and Murphy's required to know it, which is evidence that Murphy's deliberately, calculatedly, intentionally engaged in all the crimes described herein. Murphy's in bad behavior and fails to be a judge. Murphy's demonstrated he fails to be neutral or unbiased. Instead of bought and paid for a clerk working for a Deer Park cash cow for his own personal gain, Murphy's in bad behavior and fails to be a judge. Murphy intends to be accomplice to the privateers in a mixed war. Mixed war is on one side by public authority, on the other side by private persons. Under international law of warfare, all parties to a cause must appear by nom de guerre, because an alien enemy cannot maintain an action during a war in his own name. Murphy's in bad behavior and fails to be a judge. Murphy's demonstrated he intends to degrade the respondent in error in his kangaroo court staffed with U.S. citizens and his show trial. Murphy intends to subject the respondent in error to his despotism under his military dictatorship. Some cites from Chisholm versus Georgia. The power which is derived cannot be greater than that from which it is derived. And that's maxim of law. When they know that no government employee is competent to sit on a jury, an employee of the United States not qualified to sit as a member of the grand jury in any district. The only jurors possible for U.S. citizen slaves is taken from voter registration rolls as required by the Reconstruction Acts. And 5 U.S.C. 552 AA 13, the term federal personnel means individuals entitled to receive immediate or deferred retirement benefits under any retirement program of the government of the United States, including survivor benefits. In other words, federal personnel, anybody with a Social Security number is federal personnel. And it's impossible for the respondent in error to be a U.S. citizen since the respondent in error failed to be born or naturalized in the jurisdiction of the United States as required by their edict under martial law, 14th Amendment, as previously declared herein. Therefore, U.S. citizens failed to be peers of the respondent in error. Murphy's in bad behavior and fails to be a judge. Murphy's demonstrated that it is not a court. Officers of the court are deemed to know the law. Murphy's in bad behavior and fails to be a judge. Murphy's demonstrated he intends to personate a judge in his military court. That's impersonating a public servant. Murphy intends to conspire. And this is, again, going to felonies, some of the felonies that they're involved in. Because under international law, they love to assault people with consumer goods, fail to be subject to taxation, and automobiles used for carrying passengers or property for hire is considered business equipment, and an automobile used for any of the goods purposes, consumer goods, and it's a malicious prosecution. And Murphy's in bad behavior. Murphy's demonstrated he intends to be accomplice in their malicious prosecution. Demonstrated he intends to accomplice to engage in false arrest, try to get away with it. And so we're getting close to the end. We're only 10 pages away. And that's just without the attachments. Of course, the attachments will go pretty quick. If their judges want to assault me with their unrostered, there's been no breach of peace or lawful arrest. There's some court cases. There's a bunch of them here. The only thing the plaintiff needs to do is allege a false arrest is either that the defendant made the arrest or imprisonment, or that the defendant affirmatively instigated, encouraged, incited, or caused the arrest or imprisonment. When the plaintiff is shown that he's arrested, imprisoned, or restrained of his liberty by the defendant, the law presumes it to be unlawful. The burden is upon the defendant to show that the arrest was by authority of law. Any arrest made without proper warrant, signed by a judge, backed up by an affidavit from two persons that states, under a penalty of perjury, you've broken a contract or hurt someone, if challenged by the defendant, is presumptively invalid. The burden is upon the state to justify it as authorized by statute and does not violate constitutional provisions. As in the case of illegal arrest, the officer must keep within the law at his peril. If demanded, he must produce the warrant and read it to the accused, that he may know by what authority and for what cause he is deprived of his liberty. An accused person, if he demands it, is entitled to have the warrant for his arrest shown to him at the time of the arrest. A special deputy is, okay, and so there's a bunch of court cases. A capias is not a warrant. If they fail to be acting in good faith, okay, and so there's Congress has given them an out by saying it's in good faith, and the same thing applies in the Texas region of their criminal corporation, and it's all with Murphy's approval, consent, selling their justice, so then they can call it a contract. And Murphy's in bad behavior and fails to be a judge and is therefore personally responsible in his private capacity and has no immunity whatsoever. Murphy's demonstrated that he intends to be an accomplice under 18 U.S.C. 247, subjecting me to their satanic religious ceremony. Official oppression. Murphy's in bad behavior. Murphy's and his gang of privateers have satisfied none of the 7 elements of jurisdiction. If Murphy cannot take away citizenship, then neither can they force it upon you. Murphy and his Roman cult bar member buddies have used their military dictatorship to criminally convert citizenship into the opposite of what the founders contemplated. And here's some court cases that talk about it. And while the 14th Amendment does not create a national citizenship, he has the effect of making that citizenship paramount and dominant instead of derivative and dependent upon state citizenship. The amendment reversed and annulled the original policy of the Constitution. And so then I go through that under the corporate denial affidavit, I'm an American national, and you can read those if you want. I mean, we got to get moving on this. And because the respondent error is a free inhabitant as found in Article 4 of the Articles of Confederation with all the rights and privileges of citizens in the several states, defendant error is also a judicial power citizen. Murphy and his gang of privateers are engaged in a seditious conspiracy. Murphy's in bad behavior and fails to be a judge. Murphy's waived an immunity he may have enjoyed, is fully liable in his private capacity, and his so-called court is a kangaroo court, and it's a malicious prosecution. Murphy's in bad behavior. Everything Murphy's so-called court does is a fraud and a nullity under color of law. By assaulting the respondent error with their fictitious U.S. citizen, which is a fraud, criminally converting the respondent error proper appellation into a fictitious fraud, by criminally converting my postal address in the land of Texas to your District of Columbia territory with the use of a zip code. All satanic children of the devil, and your judgment day is coming. And at common law, they would all be put to death. If a man be found stealing any of his children of the brethren of the children of Israel, maketh merchandise of him or selleth him, then that thief shall die. Thou shalt put evil away from among you. Which is why they need to orchestrate their military dictatorship, because it supersedes and replaces common law. And that's taken from the Causes and Necessities for Taking Up Arms, 1775. To supersede the course of common law, and instead thereof to publish nor the use and exercise of the law martial. Constitution of the United States of America requires that lawful Article 3 judges be provided, but Murphy's demonstrated the intents to perjure his oath by subjecting the respondent error to the deprivation of his right to a Republican form of government, an Article 3 judge in violation of 18 U.S.C. 242 in a malicious prosecution. Murphy's in bad behavior and fails to be a judge. Murphy's demonstrated he intends to extort Federal Reserve notes from the respondent in error as evidence in his arraignment, a true copy of which is attached here to, all of which is incorporated herein by reference in its entirety. And this is Clearfield Trust Company versus United States. Read it already once. All District of Columbia territorial courts are using their Uniform Commercial Code, regulated by their Unidroit Treaty under the International Institute for the Unification of Private Law, which the United States has been a signatory to for over 30 years, which is unconstitutional because treaty power can only be used externally. and this is U.S. Supreme Court, Bond versus United States. You have no authority to use your Unijoint Treaty in America, and your use of the Uniform Commercial Code is unconstitutional. And all statutes are for U.S. citizens under the Commerce Clause and under international law rule as edicts under the military, martial law military despotism. Because you intended to assault me with your quasi-contract from the beginning of this proceeding. Ignorance of the law is no excuse. All officers of the court are presumed to know the law. Murphy's a bar member, is required to know that he's operating as a bought and paid for clerk masquerading as a judge. He cannot do anything judicial like issue warrants or orders. As part of Murphy's intent to engage in official oppression, abuse of official capacity, as well as Murphy's intent to conspire with Baxley, the other ones, and their gang of privateers to threaten, injure, oppress, and intimidate the respondent in error to the free exercise of his right to a Republican form of government. Again, it's talking about the felonies. Murphy's required to recuse himself when he cannot be neutral and unbiased. Murphy failed to do so, which is evident that Murphy intends to be a bought and paid for clerk masquerading as a judge, impersonating a public servant, obstruct by force and threat the free exercise of the respondent in error's Christian religious beliefs and his desire to refuse to participate in Murphy's satanic religious ceremony and his pecuniary penalties. Engage in official oppression, be an accomplice, their gang of privateers in their official oppression, be an accomplice to, anyways, I just go down and it's going through the felonies again, and there's a bunch of them here. Respondent in error filed a verification of complaint for his fraudulent fictitious charges as evidenced by the arraignment, a true copy of which is attached here to all of each of which is incorporated herein by reference in its entirety in the form of an affidavit. And the defendant is shown to be a Sestake trust, and the respondent in error fails to accept responsibility for the Roman cult Sestake trust by I fail to understand the charges, thereby removing the controversy. The respondent in error then filed a Form 1020, a true copy of which is attached here too, all of which is incorporated herein by reference in its entirety, wherein the respondent in error offers to pay the alleged debt, but needs to know what form of lawful payment is required. But Murphy and Butler have failed to respond. The respondent in error served a notice of default and opportunity to cure on the 13th of April by certified mail, and then a final notice of default on the 8th of May. A true copy of which is attached here to all of which is incorporated herein by reference in its entirety, all of which is proof that they've refused my offer to lawfully pay this alleged debt, which means there is no debt. And is under Texas Business and Commerce Code, the tenor of payment of any obligation to pay an instrument is made to a person entitled to enforce the instrument, and the tenor is refused, there is discharge. Under their private international law, these bar members love to perjure their oath to assault people with. This is proof that Murphy intend to perjure their oaths, intend to engage in multiple felonies as described herein, and are pirates, privateers, and thieves. And Murphy's in bad behavior and fails to be a judge. The bought and paid for clerk masquerading as a judge fails to be competent to be a lawful judge under the Constitution of the United States of America. Article 3 has demonstrated that he intends to be a military commissioner under General Orders 100 in furtherance of his seditious conspiracy, impersonating a judge, and is deliberately, calculatedly, and maliciously violating my rights and immunities under color of his codes, rules, and regulations. And respondent in error sealed this declaration pursuant to locus sigilli. And that's the end of it. Okay, so then we'll look quick through this is the Form 1020. And I've got that Form 1020 video, so if you want to see what I do, first of all, you got to understand, you got to tie it all together. Okay, so this ends at page 55. So then I start hand numbering, okay, 56, and I hand number them all. Okay, so there's going to be 106. There'll be 106 pages. It'll go up to a page 106. We'll go through them pretty quick. See, this is all proof of service, okay? And notice of default and opportunity to cure. I've attached a copy. You're in default of providing a method of payment, and you're notified that if your attorneys fail to complete this form that is filed, I will be adding this issue to the lawsuit that I'm already preparing. This has given me great evidence against you and your Deer Park Cash Cow LLC handlers and your intent to engage in multiple felonies, official oppression, mail fraud, sending threatening mail, impersonating, perjury of oath, and more. And let's go and say look at the final notice of defaults up here. We'll read that one too. Yeah, this is the final notice of default. You demonstrated that you intend to conspire together to threaten me, oppress me, injure me in the free exercise of my common law right to travel with my private property on the public highway. You've demonstrated that you intend to subject me to the deprivation of my common law right to, under color of your Clearfield doctrine. And this is your final notice of default, and your failure to provide the required information means that I own nothing, and you're a gang of thieves operating under the Clearfield doctrine. I kind of get a little bit belligerent sometimes, but I think I have every right to. You know, I mean, man, they're just nothing but a bunch of thieves. Anyways, this is the Form 1020, and it's using this, right here is the arraignment. Okay, so right here is they want 183 something. So what is it? And that's what the Form 1020 says. If you go here, it says, under the caption Citation 1 failed to display DL, what does the number 183 refer to? I mean, they can put other, if they want gold or silver coin, they can put other, click that and say gold or silver coin, but they never do. And in fact, if you went in there to pay them gold or silver coin, they would convert it into Federal Reserve notes, okay? And so they are nothing but thieves, okay? Remember, Clearfield doctrine is that when they are dealing with Federal Reserve notes and checks, that they're not government anymore. And so this exposes all of that. And here is the last service. And then it goes on. This is the verification of complaint. This is one that the legal entity's name. So it's one page. That's all it is. The legal entity's name, Fern Glen Winningham, is assessed to K Trust defendant herein. See right here, State of Texas versus Fern Glen Winningham. That's how they put it on their paperwork. I have read but failed to understand the foregoing complaints filed herein, and each fact alleged therein is true and correct in my best first-hand knowledge and belief. And so I'm not disputing a word of it. It's all true. But I don't understand it. Anyways, and so then I attach, this is the complaint, right? And the corporate denial affidavit. Now, the corporate denial affidavit, we're going to just read a couple things in here. Texas Rules of Civil Procedure. Now, other states won't have this. They'll probably have something similar, okay? Texas Rules of Civil Procedure, Rule 52. An allegation that a corporation is incorporated shall be taken as true unless denied by the affidavit of the adverse party, his agent, or attorney, whether such corporation is a public, private corporation, or however created. Okay, so that's why you file a corporate denial affidavit. You have to, you want to make it, you get it recorded, first of all, in the county, because then it's public document. It becomes the unrebutted truth and public policy, okay, and that's really powerful. There's court cases that talk about it. Failure of any adverse party to deny under oath allegation that party is a corporation dispenses with the necessity of proof of that fact, okay? So if you don't deny it, you're a corporation. When the complaint is lodged by the government for a fine, fee, tax, or other revenue, they are imposed only on corporations. If respondent is not a corporation, he cannot appear and plead. So it's a catch-22. They go and assault you, and they'll send out their KPSs and their low intelligence thugs will assault you and drag you in there. Oh, he appeared. He's a corporation. Okay, that's exactly what they do. These people are just the lowest form of life there is. Don't get me going. You're going to get me going here. Anyways, so that's probably that stuff explains the importance of this corporate denial affidavit. Now we're going to go into the statement of original status, and that's down here further. I've got a video called the Foreign Sovereign Immunity Act, and you need to watch that. It talks about the statement of original status. It's actually a talk radio program with a guy by the name of Al Barcroft, and he's passed away now. But the important thing is that you need to understand that this is like the silver bullet, okay? Because they can't do anything about this, okay? The statement of original status says that I was given birth by my mother, who is an Oklahoma State citizen. And I don't put my date of birth, but I put hers down. And she was given birth by Quitman Elbert Winningham, her father, and her mother was Ruby Mae Atkins. And her father and Ruby were joined in the state of holy wedlock, and her father was sired by James Carleton Winningham, and now we're going back to 1856. Okay, so that's before the Civil War. So that's really all you need to do is go before the Civil War. But if you can go before the War of Independence, it's like a home run. Okay, anyways, so this is my ancestry on my mother's side, going back. Now this is I really like this paragraph here. I affirm that I, Glenn Winningham House of Fern, of the Adamic race, as white Christian male, I do not now, nor would I ever voluntarily give up my unalienable, which means cannot be taken away, God-given, constitutionally secured Christian rights and responsibilities. For I, Glenn Winningham House of Fern, have never knowingly given up my birthright as one of the direct descendants of the posterity, as noted in the preamble of both the Arizona State Constitution, the Constitution of the United States of America, and its Bill of Rights, and also designated in the Declaration of Independence for him, because my fifth great-grandparents, who were James House of Winningham and Sarah Nichols House of Winningham, whose grave sites and gravestones are clearly marked, and now serve as an at-law public notice of their once existence of their judicial power citizenship status. This is like really powerful, which was passed on to me, Glenn Winningham House of Fern, as an inheritance. For and because James J. House of Winningham was naturally given birth in the 1756 on the land now known as Prince George County in Virginia Colony, which ultimately became Virginia State, a state in the Union States of America under the Articles of Confederation, 1781, and the Constitution for the Republic of the United States of America. And whereas James J. House of Winningham, given birth in the year 1756, and Sarah Nichols House of Winningham, given birth in the year 1760, were joined in the state of holy wedlock in the year 1792, were living on the land now known as Randolph County, Virginia, a state in the Union States of America. And these pioneers were the people who were part of the process and an action that eventually led to the establishment of statehood enabling acts of Congress. In other words, 1796 for Tennessee, 1821 for Missouri, 1905 for Arizona, which then allowed the 5,000 free white males within the boundaries then designated as territories to create said states, as found in the verified abstract declaration of order, which is recorded in the Pinal County Recorder Number, which is the unrebutted truth in public policy, a true copy, current pedigree chart, and the true copy of the current pedigree chart, which is attached here to, all of which is incorporated herein by reference in its entirety. And then the maxim of law, the right of blood and kindred cannot be destroyed by any civil law. The United States has no authority to go outside constitutional limitations under any circumstances. And this is Home Building versus and Loan Association versus Blaisdell, U.S. Supreme Court. Emergency does not create power. Emergency does not increase granted power or remove or diminish the restrictions imposed upon power, granted or reserved. The Constitution was adopted in a period of grave emergency. Its grants of power to the federal government and its limitations of the power of the states were determined in light of emergency, and they're not altered by any emergency. Anyways, therefore they have no authority to delegate police power to municipal corporations. The municipal corporation called Judiciary Court, State of Texas, and their parent municipal corporation called State of Texas are an unconstitutional delegation authority and a fraud and a nullity. All administrative, all law enforcement agencies, anyways, I go through color of law. Anyways, that is. And then, so then there's the pedigree chart, okay? And what I'm essentially saying there, if you don't like one line, I got a whole bunch of other ones you can pick from. And so there's my grandfather, Quitman Elbert Winningham, James Carleton Winningham, Clementine McDonald, John Alston Winningham, 1808. And then there's a second page, John Alston Winningham here. And it goes back, William Winningham, 1732. And so... and there's a bunch of other ones. John Mayfield, 1724. William Todd Livingston, 1714. I got, if you don't like one, we can pick another one. Anyways, and then this is the Daniel Lee Swank affidavit that talks about the judiciary courts of the state of Texas, right here. And Supreme Court building. CHOP executive is Tom R. Phillips, Chief Justice. Okay, so the Chief Justice was this was done in 2004. Anyways, so this is part of what's attached, and so then this is a certified copy that was attached. There's the passport. This is the birth certificate, showing that my mother I was American. 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 That's interesting. I guess that's like Canadian, only American. Anyways, that's a certified copy. And then there's Jeff Gibson's oath of office, and the cop's oath of office, and Baxley's oath of office, Tim Murphy's oath of office, statement of office, and then the police report, and that's it. And what I did is I served this on them, and their police report says I'm white. And so again, you use everything you can. Now, see right here, race white. Now, if you go back to that statement of original status, you got to watch that video on the Foreign Sovereign Immunity Act. The guy, Al Barcroft, did a lot of actions where he basically got the court to declare that he was a foreign sovereign. And he said anybody of any race could do it, because who knows who was sleeping with who in the 1700s. And, you know, I'm not going to tell you to make things up, but he suggested that you could, because who's going to call you a liar? So it's up to you. I'm not telling you to do that. But these people are just nothing but a bunch of thieves. You know, they're just nothing but just the lowest form of life there is. They're just absolutely, don't get me going. You're going to get me going here. But anyway, so you notice the page numbering is continuing. 102, and it goes to page 106. So that's the end of it. That's the police report. This is what got filed. And what happened is, I filed it into the case, and I sent them 3 copies. The court was closed, so I had to send them by certified mail, 3 copies with a self-addressed stamped envelope and instructions in there. Let's see if I can find the instructions, in fact. Here we go. This is what I sent for instructions. Come on, there we go. It's real short and sweet. Since you're denying due process by keeping your office closed and denying my right to file documents into your so-called court, see, I sent it by certified mail, so I tracked it. Please find enclosed an original and 2 copies of a notice of void judgment to be filed under the cause indicated. The talk document sticker. The other 2 are a copy for the prosecutor and a copy to be returned to me in the self-addressed stamp envelope. They never did return it to me. And there's my proof of service. Anyways, and then I got this in the mail a couple days ago. So it's dismissed. But you know what? I filed this bar grievance complaint, and I filed this, you know, after they had theirs in the mail. So I really had no idea that they were going to dismiss it. I was just going for the jugular. Okay, so I mean, you got to just give it your best shot. That's the enemy. Okay, remember, the guy that dismissed it is the prosecutor. After further review by the prosecutor, the case has been dismissed. Okay, that's the enemy. Okay, that's the guy you got to go for. And so I actually filed a bar grievance complaint. And I'm not going to go through the affidavit. I have a video on the affidavit, and so you can go through that if you want. But I filed this bar, and it's already sent. So I mean, if I'd have known he was going to do that, I probably wouldn't have done it. As a matter of fact, I got his boss's name, and I was getting ready to file one against him too. But I won't, since they dismissed the case. I'll let it die. But again. This is warfare, okay? The best defense is a good offense, okay? You got to go on the attack. You have to be building a case right from the beginning. If you go around, oh, please don't hurt me. Oh, please, I'm so sorry. You're gonna get to spend some time in Crowbar Hotel, okay? They are not interested in justice. They are interested in selling people into slavery. You know, don't get me going. You're gonna get me going here. Anyways. That's the end of it. I appreciate you watching. The case got dismissed. And so this is like, for me, this is like major victory. And now you know what I did. I think it was this notice of void judgment, but you know, it could have been the bill of particulars that helped. You know, that could have been contributing factor when they got this. Then they figured, oh, you know, this is a big problem. Anyways, you know, I don't know, but I can tell you that I have, I've filed. The U.S. attorney's getting copies of this stuff. I'm hoping those cops end up in jail, okay? Because you know, they need to get some free room and board in Crowbar Hotel. What they did, you know, they got no business messing with people like me. And matter of fact, the one cop, he actually said, "Oh yeah, we normally just arrest anybody from the Republic of Texas," and so, you know, he needs to get some free room and board. Anyways, you know, that's not up to me. It's a good thing it's not up to me, because, you know, I might do something I might regret afterwards, and so I'm glad it's not up to me. But the bottom line is that if justice is available, okay, it's not, you know, we do have good people working in government. Let me put it that way. We do have good people working in government. There's a lot of crooks, there's a lot of criminals, but there are good people there, and they decided to make the right choice in this one, and I'm glad. Got no arguments from me, and so don't lose hope. You know, never give up, never ever give up. You know, keep fighting the fight. You know, what is it that Paul said? He fought the good fight, right? You gotta. That's the best tribute anybody could ever have, is they fought the good fight, and so that's what you got to do. You know, you got to fight the good fight. Anyways, thanks for watching. I hope this helps you, you know, because it gives you an idea on what you need to do, and free yourself. Anyways, thanks for watching.